Welcome to the Jury Thinks What podcast. Part of the Lawyer Minds ecosystem, the Jury Thinks What podcast discusses everything there is to know about trying cases, from preparing the case before the lawsuit is filed, all the way to trial. And most importantly, how to understand what the jury is thinking. During our journey, we'll be talking to some of the brightest trial lawyers from many walks of life. What makes them successful? What makes them different? Do they have secrets to dealing with the jury? Let's find out. Here's your host of the Jury Thinks What podcast, Saul Gruber.
And thank you again. I appreciate everybody tuning in. This is Saul Gruber from Gruber Trial Consulting, and you are listening to the Jury Thinks What, a podcast by trial lawyers for trial lawyers, where we discuss issues that those of us with boots on the ground deal with every day. And today we're going to talk about something which I think is really interesting, and that's trucking cases. You know, we hear from a lot of people throughout the country that trucking cases are different than auto cases, but we don't really hear why. And today we have a guest who is a certified trucking expert as a lawyer, and Jay Vaughn from Louisville, Kentucky, is going to talk to us, and we'll talk to us about all the different things you have to do when you get the trucking case just to file suit. And then some tips on discovery, but there's so much to do. And I really want you to listen to what Jay has to say, because if you have a case and you don't know this, you're going to be in some trouble. So you can call Jay or other trucking lawyers in your area, but whatever you do, make sure you contact somebody so you have all the right information to protect your clients. So here is Jay Vaughn, trucking attorney from Louisville, Kentucky, on the Jury Thinks What. Okay, and we are here on the Jury Thinks What, a podcast by trial lawyers for trial lawyers. And again, as everybody knows, I'm your host, Saul Gruber. I am here with the ginger one, Jay Vaughn, out of Kentucky. Jay and I have been friends. I know I say that a lot during this podcast, but Jay and I really are friends, not just acquaintances, and for a lot of years. Jay, thanks for coming on. I really appreciate it.
Saul, glad to be here. Appreciate you having me on. But more importantly, I'm just happy to talk to my friend. And, still my wife talks about the first time we met, you stood up on top of a bar and made everyone be quiet. And you made an announcement, and that was my first AAJ event. So
yes, yeah. I may have gone through that phase in my life of about 50 years of standing on the bar and screaming everybody to be quiet. But today you don't have to be quiet at all. Today, everyone is tuning in for you. Jay handled nursing home cases for a lot of years and decided years ago, and I remember when he did it, that trucking was for him. Since then, Jay, I don't want to embarrass you, but I'm taking a look at some of your cases and I'm blown away thinking I knew you when you were little. A $10 million trucking crash settlement, $7,250,000 for a truck settlement, 2.8 truck settlement, 2.4 truck settlement, 2.3. I mean, it just goes on and on and on. That's incredibly impressive, my friend.
Thank you. I appreciate that.
And just as important, because again, this is a podcast for trial lawyers. Jay was one of the first lawyers in the country to be certified as a trucking lawyer. Is that right?
Yeah, it's true. It's, back in, I think it was 2019, the ABA approved a new accreditation, board certification for truck accident law. So it's put on by the National Board of Trial Advocacy, so NBTA, that does other certifications for like appellate and civil procedure and trial. But they approve one for trucking, and it was a multi-year process of the two lawyers who Joe Freed, Michael Leisman, put together the argument and the data that there should be a truck accident certification. It was approved, and then I signed up, and in the fall of 19, I took the test in Indianapolis. It was 6 hours, man. I mean, longest test I've taken. I mean, only test I've taken since the bar exam. Yeah, and I got barred in 2002 in Ohio and 2003 in Kentucky. So I hadn't taken a bar exam for 16 years, and it was 6 hours. And it wasn't wink wink, take this. I mean, it was hard. And then the other part, real quick, Saul, is besides the test, you had to submit this packet of referrals from plaintiff lawyers, defense lawyers, judges. I mean, I had to call a federal judge asking for a recommendation and a writing sample. And then you had this matrix. That was the hardest part. You had this matrix to fill out, and you had to have enough points. And you had to go, I had to go back you go back like 7 years on cases. And it was hard. Like, how many experts have you deposed? How many inspections have you done? Have you ever filed Daubert motions against a defense expert? It was rigorous. So I was proud to become one of the first 10 in the country.
We had the same type of test in New Jersey for trial certifications, where we had to have different, we had to give all sorts of questions. You had to answer all sorts of questions about how many trials you've had, how many days of trial, things of that nature. So we know that if you're going to be certified as a trucking lawyer, that means you really need to know a lot about this stuff. Is that fair?
Yes. Oh, it's, I mean, yeah, if, anyone can take it, but if you didn't have enough experience on the matrix, you couldn't get certified. And that was that's what separates most of the people that have looked at applying versus those that have actually been board certified is the actual, proofs in the pudding, right? Can you prove you've done the work?
So I find it interesting because, we hear a lot of people say, we have a trucking case and they're talking about it as if it's just like a regular car crash case. Now, I know from listening to you, Joe Freed, and some other people, my former partner, Larry Simon, that ain't true. Why don't you tell our listeners why it's not true and what the differences are?
Sure. It's a great question. It's something that's really important for all the listeners, because I mean, we've all at one point or another in our career have done the regular car wreck case. And that's, Joe Blow says, and Jane Smith, there's a rear end collision, hey, I didn't see the light turn and I hit you, sorry. When you look at trucks, commercial motor vehicles, it's a totally different landscape, because those drivers are professional drivers. They have to take a special test to get a commercial driver's license, and there's special rules that apply to those drivers that don't apply to you and I in our car, Saul. So, there's a whole body, just like, I mean, with your background and being really, for me growing up in the law, the guru to me in nursing home, just like you got the federal regs in nursing home, you got the federal regs for trucks. And there's so much more responsibility there as a truck driver, because you have to imagine, you have a 4,000 or 5,000 pound passenger car versus an 80,000 pound semi. Big truck hits small car, bad things happen, but you got to get to the why, just like you do in nursing home cases.
Right.
Why? What's the root cause of why did this happen? And so you have to approach a trucking case as kind of a puzzle to put it together. And really the other difference is there's so much more data on trucks because of the technology in the trucks. You have to understand what you're looking at. When you inspect these trucks, inspections are a big piece of this that I think a lot of lawyers miss.
It's interesting. So we always know that whenever there's a plane crash, right, the first thing I think of is, well, where's the black box? Right. I don't know what a black box is. I've never seen a black box, but I know it's important. Is there something like that in trucking cases?
Absolutely. So cars have them, but trucks go a step further. So trucks will have, an electronic module, engine control module, ECM sometimes they're called. So some trucks in the engine will have this box or this module that you can tap into, plug into, download data that has speed, that has percent of throttle, when they hit the brakes, different steering mechanisms. But that's a piece of it. As technology has advanced, now these trucks have what they call a telematic system. So usually it'll be some type of computer system in the truck with a dashboard, and it uploads everything to the cloud. It will contain driver behavior, veering out of lanes, hitting the brakes too hard, speed data. It will include things like the performance of the truck. And all truck drivers have to have what's called electronic, you have to keep, you used to have the old log books.
Right.
Where you record your time.
So we don't do
now
that anymore.
They've all gone to electronic logging system, and there's certain requirements that these systems have to comply with the federal regs. So you have these electronic logs tracking what's called their hours of service, their legal time to drive. So
Let me ask you a question based on what you just said, Jay. And all that stuff gets up to the cloud.
Correct.
So it's almost impossible, if you're doing it right, for them to say, oh, sorry, it's been deleted.
Well, what they say and the truth of what they say are different. I mean, they a lot of times they'll say, well, the camera, the driver's camera was turned off, or the video only is kept for a couple of days. Well, then you contact the manufacturer of that software. Like, oh no, the videos we saved for like a year, and you just have to make the right request to the right department. Because the company, the motor carrier, the truck company will have their own platform or their way to monitor that data. But then, it's the truck company didn't create the software. It's Verizon has their own. There's a program called PeopleNet or Keep Trucking. These vendors, just like we have in law, these vendors, just like you have, audit trail companies and medical record companies, same thing for trucks. They create this software and they sell it. And they say, hey, we have the best thing on the market. Here's our bells and whistles. What you find though, it's just like if you get DirecTV, there's a subscription package. Do you want the basic, or do you want the Showtime, the HBO, and all the sports channels? So when you're in these cases, you have to not just learn what program they have or platform, but say, hey, give me a copy of your subscription agreement.
Right.
Then you get in it and you say, you chose the $9 a month package. If you just chose the $12 a month package, you had all the other safety features that may have prevented this crash. So some neat back and forth you can have with the company on the decision they made and why they made it. Usually it comes down to money, right?
Well, I'm going to be 58 this year, and as you know, I've been married. I've not been married. It all comes down to money. I think everything seems to come down to money in life, except for love, but everything else is down to money. So I want to talk to you about this black box, because it seems like this is a really big part of trucking litigation is A, getting it, B, and then B, knowing what to do when you get it. Correct.
So
let's talk about that. How do you go about getting the black box?
And I'm so glad you got into this, because there's a misunderstanding about how you do it, how you go about it, and when you can do it. So the earlier you as the lawyer get in the case, the better, just like any case, but time is an issue. So, there's a lot of cases, unfortunately, that I get brought in to co-counsel by the lawyers a year, sometimes 2 years later, and say, hey, we need to file suit. Well, evidence is gone by then. What you want to do is the soonest you get the call about the case, whether you know it's the case or not, because sometimes you just don't know till you get into it, you got to find out who the truck company is, and get a preservation layer, spoliation layer to them to preserve a bunch of stuff, mainly preserve the truck. If there's a trailer, preserve the trailer, because the trailer has data that you can download sometimes, but you want to preserve it and then say, if you're not going to preserve it, let us know so we can, go ahead and file suit or whatever, but please confirm you'll preserve it, because, you want to get in there and download it with the right expert. But there's a couple caveats to that. Number one, sometimes if it's a fatality, for example, most time the police will impound the truck. So you got a little bit of breathing room until they close their file. A lot of times the trucks will stay in an impound lot for, 4 or 5, I've had up to 6, 7 months. Good. The problem is sometimes there's a bad crash, but maybe the truck is drivable from the scene. Well, sometimes depending on the make and model of the truck and the type of engine, if they drive it from the scene, we had this happen once where the police drove it a mile down to a rest area, it wrote over the data. The data was gone. So it depends on the truck. It depends on certain engines will capture more data for longer. But so how do you get to it? You got to immediately get in touch with the truck company, their insurance carrier, the driver, the police, the tow yard. If it's at like a vehicle storage place, like a Copart, you got to like mass letters out everywhere, and not just by mail, FedEx, certified mail.
So if I'm hearing you right, and I've heard this from other people, but to be honest with you, in one ear and out the other, you're telling me you've got to immediately make arrangements to get that black box or have it preserved, as well as the truck and the trailer. It's not enough just to have the black box.
No, absolutely. Because the black box is going to be in the truck. You don't want it removed. If it's removed from the truck the wrong way, then the data can be lost. And there's times when you have to have it removed, but then you got to do a chain of custody, and it's a whole mess. But in general, it's inside the truck, and you got to be able to get to it. But what's important is not just getting to the truck, making sure the truck has power. Do you have the key? Because if you don't have the right power to it, you can't get to the data. You don't have the key, obviously you can't turn the ignition, you can't get to the data. But sometimes if you do it wrong and you're experts, if the cables are hooked up wrong, sometimes it can erase data. So there's a lot.
Let me ask you this question, and I'm sure everybody's thinking the same thing. If that data has already been uploaded to the cloud, why would doing something on the ground erase that data that's already been uploaded?
So some trucks, the actual module in the engine can be on and can record data. On top of, separate from that, they can have a telematic system in the cab, and that also can be tied and also record separate data. Sometimes you'll have each. Sometimes the trucks will have a telematic system only for logs, for e-logs, but it doesn't record engine data because maybe they didn't pay for that subscription, right? They paid for a cheaper one. They just said, hey, we're just doing it for e-logging because that's mandated. We don't have to have, there's no mandate that we have any engine recorder on here, in our telematic system. So yeah, so sometimes it's tied to that telematic system. Sometimes it's just tied to the module in the engine. But then the next step is, depending on the make and model of that engine, your expert may not be able to download it. For example, if it's an engine by Volvo or Mack, there's only 3 companies in the United States that are allowed to download. They're authorized to download Volvo or Mack engines. One's in North Carolina, one's in California, one's in Colorado. So you have to pay those people a lot of money because they obviously have the corner of the market, and they're the only ones that are authorized to download those vehicles.
All right, so let's take a step back. So if I hear you, you're telling me that if I'm a lawyer and someone calls me and said they got hit by a truck and unfortunately my wife passed away or something, there's certain, you either have to bring a trucking lawyer in that day, or you need to find out who the best trucking lawyer is in your area, call them and say, what should I do?
Absolutely. I mean, absolutely, because evidence preservation is job one. That is job one the moment that call comes in, because once it's gone, guess what? It's gone.
It's gone.
And you got to think, a lot of times, do you think the insurance companies because real quick, when a crash happens, if the truck driver is, conscious, is able to call and he or she, are okay, the first call they make isn't 911. The first call they make is either, depending on the size of the truck company, is either the company, the safety director, or dispatch. That's usually the first call or text they make. And then they go, the dispatcher or the company then contacts the insurance company. And what you find is within hours of this has happened, within hours of a fatal crash, while your client's loved one is, being taken off to the hospital, to the morgue, whatever, defense lawyers are on the scene with their experts. And of course, your client doesn't have that luxury to have a lawyer on the scene. But if you don't get that letter out early and they get that truck and they haven't heard within a couple of weeks or 30 days, what do you think the truck company does? They repair the truck. Why? That's money to them. They want to get that truck in service. And do you think that they just voluntarily say, well, we may be contacted by a lawyer in a couple months or a year. Let's just go ahead and download all this data to help them out. Oh, right. They don't do it. They get rid of it.
So really, unless you put them on notice, there really is no spoliation claim because they're under no obligation to keep that information.
Correct.
So now you do that right away, and then you can figure out the case afterwards. But now it's, I don't know, 6 months later, 8 months later, you're getting ready to file suit, and you presumably have the black box information. You presumably have your expert who did an inspection already. They're the big things.
Correct.
What do you do with that information once you file a lawsuit?
So what I like to do is when I file the suit, especially if it's a case that I am in or I know I can keep it in state court, I like to file not just a regular request for reduction of documents. I like to file kind of a 30B5 notice, basically to take a records custodian depot. And I do a laundry list of documents that I think are relevant to the case. And there'll be fight over it here and there, but I want to get a human under oath with the documents and go through all the documents to make sure what they produced is accurate, what search they conducted, why they don't have a certain record. We always find records that, we didn't look in the safety folder. Oh, okay, well, can you do that for me? And I want to get a full set of documents first, whether it's policies and procedures or employee manuals, or, what's different in a trucking case that you don't have in a car wreck case is there's a specific type of file that's federally mandated for all truck drivers called a driver qualification file, with a ton of data in there, information on their background that they're supposed to do and their driving experience and drug testing and training, and whether they're medically qualified to be operating the truck. So there's a file and there's a lot of stuff you want. So unlike a car wreck case where I can just go and take a depot and let's figure it out and move on, I need to know what documents exist before I really substantively start deposing people with the truck company. Also, the importance of doing this early is you may find other responsible parties outside of the truck driver and truck company.
Well, I have two questions for you based on what you just said. Why do you want a live person in a corporate deposition setting as opposed to just a simple request for production of documents?
My experience has been a standard request for reduction in documents is answered by the lawyer, objected to by the lawyer, and they never give you anything. And then you have to do a motion to compel, and you go to hearing on the compel, and they go, "Judge, this isn't relevant." And the judge goes, "Well, Mr. Vaughn, they gave you this. Why is it relevant?" Well, because I think I want it. It's been good in other cases where if I get to do if I know it's a deposition, the only way they get out is by a protective, if they file a motion for protective order. But I'll tell you, I've done probably 8 or 10 records depositions in the last 4 or 5 months. One was a non-trucking case against Lowe's, which is a fascinating case that's going on right now that I have. But in those depots, I get a human there and say, okay, request number 2 dealt with this driver file. I had it the other day, dealt with this driver file. I'm looking at the file. I'm not asking about the substance, why things are the way they are. I just want to make sure we have a complete file. I don't see his employment application. Oh yeah, that might be in this other drawer. Oh, but when you put this together, did you look in that drawer? No, I didn't. Why not? Honestly, I forgot. Okay. If I do a request, follow up, will you get that to me? Yes. And I'll go through and say, okay, well, I see this company manual. It's 20 pages. Do you have anything you give drivers on safety? No. So there's not any separate procedures or training or pamphlets no, it's just this. And we'll talk to them every now and then. Okay, great. I don't ask why. I just want to make sure I know. But it's never, when I get a human, I'll tell you, there's another point. I've had less objections from defense lawyers when I do the records deposition notice than when I used to do a regular Rule 34 request, because they take it a little more serious. They know they have the duty to prepare the corporate rep. And when they get there under oath, I mean, it's amazing the stuff I learned and what they learn. And I've had defense lawyer even tell me afterwards, I really appreciate you doing this. I've never done this before. I've never had a lawyer ask for this. I see why you do it. Yeah, it took a couple hours. It's a boring depot. I mean, depot's boring as hell. But I now learn what's there and I have a roadmap. And then it helps me decide where I want to go with my discovery for actually who I want to depose first, whether it's a safety director, a truck driver, a dispatcher, whatever.
And as you know, I've been doing them in nursing home for too many years to count. Oh, yeah. And one of the things I've always said to clients now that I work with, lawyers, when they say, well, why do we want to do it this way? I've always told them, because to do it the other way, you now have a lawyer coming up with objections. They then get to frame the objection and what the court's going to rule on. Why not take the live human who's never going to frame an objection that way? And now you're able to control the narrative that goes in front of the court. In other words, why do you need an incident report? Rather than hearing it's peer review, it's this, it's that, you're going to have a live person tell us, at least in the nursing home world, well, we want to know what happened to this resident so we make sure it doesn't happen to them again, especially if they remain in the nursing home. And now it's a whole different argument that's going to be used in court. And I've always believed in that. So I love that you're doing that. And I think I knew that you were doing that. So you're going to do that, and you're going to reframe the case based on what the human actually said to you. But getting to that particular black box, now you have that information. You have your expert telling you what the information means. How do you use that in discovery?
So there's different ways. One example could be you have a crash where, let's say the truck rear-ended your client, and you're looking at that data, and that data shows for the 60 seconds before the crash, the truck driver was maxed out at 70 miles an hour, cruise control was on. So the download will tell you that. So I have this driver going 70 miles an hour, cruise control's on, it's raining out. Well, in that scenario, one, if it's a flat road, you're on the interstate and cars are stopped, let's say due to a wreck up ahead or construction or traffic or whatever it may be, and this truck's going 70 with cruise control on, never hitting his brakes, well, what else is going on? Is he on his phone? I mean, truck drivers will look at YouTube, they'll watch porn while they drive, they'll be talking, they'll be getting coffee, who knows? That could be one distraction. 2, were they asleep? Were they dozing in and out? That could be another. 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, 20, 21, 22, 23, 24, 25, 26, 27, 28, 29, 30, 31, 32, 33, 34, 35, 36, 37, 38, 39, 40, 41, 42, 43, 44, 45, 46, 47, 48, 49, 50, 51, 52, 53, 54, 55, 56, 57, 58, 59, 60, 61, 62, 63, 64, 65, 66, 67, 68, 69, 70, 71, 72, 73, 74, 75, 76, 77, 78, 79, 80, 81, 82, 83, 84, 85, 86, 87, 88, 89, 90, 91, 92, 93, 94, 95, 96, 97, 98, 99, 100, 101, 102, 103, 104, 105, 106, 107, 108, 109, 110, 111, 112, 113, 114 And then you look at, well, the weather. Well, when it's raining, if it's raining bad enough that can affect visibility or can affect traction, something a truck driver has to do that we don't as car drivers is they're supposed to use what's called extreme caution. And there's a regulation on it, and their training tells them if it's, again, affects visibility, affects traction, makes the road more slick, then they need to have their speed reduced by at least a third. Well, if it's a 70 mile an hour,
wow, really a third?
By at least a third. And if it's really bad weather, really bad ice or really deep, dense fog, then they need to be down, a half or more less reduced, or down to a crawl to the point of getting off the road. And if it's a weather that causes them to slow down or to get off the road, which a safe truck driver would do because it's taking them out of harm's way and other motorists, then they get a kind of a break or a reprieve on their hours of service, saying, hey, you did the right thing. You're not going to get penalized for being over hours because you got off the road. Most truck drivers, though, when it's raining out really, really bad, I mean, they're what they do. They're keeping on trucking, man. They're just going and they're flying by you.
Isn't that, and that really goes to the culture of where they work, right? I mean, I understand there may be a regulation that says, hey, you're not going to be penalized for this, but if the boss says you better get there, you better get there by this time, I don't think the truck driver is necessarily looking at that regulation saying, well, I can't be harmed. So is that?
Yeah, because they have a deadline usually to get that load delivered or to pick up that load. At the same time, you find a lot of times a lot of friction between the truck driver and dispatch. The dispatch is there pushing that truck driver. You need to get back on the road. You need to get this delivered. What's taking so long? And so the truck driver and dispatch are kind of butting heads.
Oh, that's interesting.
And
is there ever a recording of dispatch?
I've not had a case where there's been a recording. Where there's been an audio recording, but a lot of times the trucks will have, like I said, that telematics system, and there's a messaging system. The most common is something called Qualcomm, where they can message drivers.
Got it.
And usually it's dispatch messaging information to drivers, and there can be messages back and forth about that.
Let's stay with that because I'm interested. So we've got that potential friction between dispatch and the driver. Do you try to use that in discovery to separate the driver from the company, so to speak, and create more friction?
Sometimes, yeah. Sometimes I'll do that, and you'll want to, because let's face it, just like, to me, even though they're more of a professional with their training and everything else, and the responsibility of the car, of the truck, and the weight, a truck driver isn't too dissimilar from a nurse's aide. I mean, the most important job in the building, right? I mean, they're there doing the hardest job, the job no one else wants to do. The truck driver is kind of the same thing. And the nurse's aide, unless you have bad apples here and there, but they're really they're doing that job because that's how they earn money for their family. And the truck driver, the most part's the same way, right? They're doing this job. Do you and I want to get in the truck and drive from here to Arizona and drop off a load and eat at McDonald's and sleep in the back of a truck and then drive back and go to these gas stations, these crappy truck stops? No, we don't want to do that.
Now, you had me at sleep in the back of the truck and have McDonald's. I couldn't do either.
Exactly. So it's a hard job. I mean, it takes a toll on truck drivers. So unless it's a truck driver who truly is doing something, reckless, where they're, watching a movie on their phone, they're Googling while they're driving, they're on meth, they're high, something else going on. If you put the focus on them and that they're the bad actor, a jury may have sympathy for a truck driver, just like a nurse's aide. And B, you're kind of missing the point. You're focusing on that day, that event. You want to back it up. The truck company maybe set that driver up for failure. The truck company didn't train that driver to understand, hey, if it's bad weather, you should slow down. Instead, dispatcher saying, go, go, go. And the dispatcher is really a company person, not a driver person.
So although you've got the black box information that's telling you what the driver did, all you're doing is setting that up to show that the company is allowing him or her to do things he or she is not supposed to do because it could hurt people from a safety point of view.
And depending upon the system they have and whatever subscription package that they chose to pay for, there could be driver behavior such as excessive speed, improper lane changes, hard braking events where they're hitting the brakes and the speed's dropping a certain degree, too fast, where it will record that moment in time where the company, either the dispatcher, the safety director, or someone within the company, are getting messages either through an app, an email, a text ping saying, hey, here's some potential bad driver behavior. And if they were monitoring that the right way and looking at it, then this could have been prevented, because they could call that driver or say, hey, you need to pull over. What's going on? You've had 4 hard braking events in the last 20 hours. That's
right.
An alarming rate. What's going on?
But the companies choose not to subscribe, to pay the extra money, so they won't know that information.
Either they choose not to subscribe, they choose not to buy the program in the first place, the platform in the first place, which is a lot of companies have them, or they're getting the information, but they're just ignoring it. I mean, now will you find the company that gets it, that talks to the driver, educates the driver, and this crash was just a one-off? Sure, that happens. But most of the time, the why doesn't point to the truck driver. The why points back to the truck company, their culture, their training, their safety program.
Follow the money.
Follow the money.
We know that phrase. So
Absolutely.
So it sounds to me like everything you're doing in pre-suit, the getting the expert, the black box, the inspecting, is to not only preserve evidence, but to make sure that the why is preserved as well.
Sure, because it's not just the black box is the most common piece of information that we learn. But what you also can download besides the black box is a lot of trucks have a braking system that also has a module or a port that you can plug into and download the braking data on that truck, which also, depend on the system, can include steering data. Did they jerk it left to the right, or jerk the wheel to the left or right too quickly? Also, the trucks will contain GPS data. Why is that important? Well, sometimes the GPS data can show you where they were and time between certain points, and does it match up with their logs? Because some truck drivers, just like everyone, can learn to manipulate a system. Some drivers have learned to reset or manipulate the electronic logging system, and so sometimes GPS data and cell phone data, or if they have a Garmin, you can use all these different pieces to kind of put together the puzzle. What else does the inspection teach you? Because there's something else that's important outside the black box. There's really 2 or 3 things. Number one, it's not always a speed or a not paying attention case. It could be they hit the brakes and guess what? They didn't slow down time. The truck didn't stop. Why? Well, you go these inspections and you get under the truck with your expert, and you see these brakes and brake drums that are just caked with just grease and gook, and you start to look at this. You see a line broken. You see there's too much air in the brake line, and you start to say,
you, Jay Vaughn, who I knew when he was in Covington.
Yeah,
you are getting under the truck with your expert to look at things.
I keep a truck inspection kit in the trunk of my car with coveralls and steel-toed boots and gloves. I have video glasses. So I'll put on these glasses that have a camera right here, and I'll turn it on, and I will film inspections, because I don't know that I didn't grow up around cars. I'm not a grease monkey. And so I'll sit there because I'll have a reconstructionist with me, and most of the time a commercial mechanic. And I'll be under the truck with the expert, the recon and mechanic, and go, what's that? That doesn't look good. Oh, look at this. And they'll take their finger and scrape it. And like, you see that? Yeah. I go, this isn't good. I'm like, awesome. I got on video. It's my work product. I can go back and watch it and learn all this lingo.
So what I hear from people, you're saying the same thing. Being a trucking lawyer isn't about sitting behind your desk and counting your money or putting questions together. It's about getting rolling up your sleeves and getting dirty.
Oh my gosh. I actually did, I don't know if you saw it, but I think last month I did an article for AAJ on my truck inspection kit. So it's in there. And I will not just go. I mean, I've been to inspections where defense lawyers have pulled up in their suit, in their dress shoes, and I'm sitting there popping my trunk and I'm putting on, they go, what are you doing? And I'm like, I'm getting dirty. Like, this is fun. Like, I'm out of the office. This is great. And I put all of my stuff, and I get my gloves, and I'm under, and I'm laying on the ground, and I'm looking, and I'm learning. And I'll go inside the cab of the truck, and I'll sit in the seat, and just to see what the driver sees. And I've seen trucks that are pristine. I've been inside trucks that would make you vomit. They were just gross, nasty stuff, which is why you need gloves, probably masks. I mean, and you look around and you know this truck is filthy. I mean, there's bags of trash, pizza boxes, there's Red Bull. What can you learn with that? Red Bull and Mountain Dews. Well, what maybe they're tired and maybe they just buy these 5-hour energies, right? And they're just popping 5-hour energies trying to get through that drive. Well, what's that tell you? It tells you that they're probably overworked. They're not getting enough sleep. They're driving fatigued. And this is something that was predictable, that was foreseeable if the company had safety measures in place.
Wow. So again, you're listening to The Jury Thinks What, a podcast by trial lawyers for trial lawyers. And we're here with Jay Vaughn from, you guys are in Lexington, right?
Louisville.
Should have known.
You
guys are with everybody else in Louisville.
Yep. And my partner, Penny, our main office is up in Norwood, Kentucky, where I used to live.
So, and we're talking about truck cases. And what I'm hearing is you're getting dirty. You're getting down and dirty. And if you're not going to win your case, and you're not going to make these kind of settlements that we've talked about.
Yeah. I mean, if you don't go to the inspection, then you're already missing out and several steps behind. If you go, but you just sit in your car on your phone, have the expert come over, hey, what do you see? Again, you're missing opportunities for gold, stuff that you can't recreate, you can't reproduce, and you just can't. You got to get a sense for that the truck driver's going through, and it gives you a picture of not the driver, just the driver, but the company. What is their culture like? Because you can have negligent maintenance cases. If they're not keeping these vehicles upright, then do you think it's foreseeable that the brakes go out one time if they're not maintaining their vehicles? Absolutely.
So if I'm a car wreck lawyer, and I learned the phrase wreck when I spoke in Covington for Jay, I don't know, 15, 17 years ago, whatever it was.
Yeah.
And, I'm from New Jersey. We call them accidents. And everybody in Kentucky said, why would you call it an accident? It's not an accident. It's a wreck. So I always do car wreck now. So if I'm a car wreck lawyer and I just want to take one dep of the driver, I'm really screwing the trucking case up royally. That's what you're telling me.
You are. I mean, if you're just deposing the truck driver and you don't know all these other documents, you don't have all this other evidence, and you just do it like a car wreck case, you just depose the driver, you're not going to get much out of the depot. You're going to miss tons of areas of information you need to build the truck case. And in the end, it's costing your client money. I mean, that's just what it is.
So now let's jump a little. Well, go ahead.
And the defense lawyers know. I promise you that most trucking defense lawyers mainly defend trucking cases, and they know how you start your case out and what you ask for and how you do your dep. They know if you're a trucking lawyer or not. And
I don't think there's any question about that.
And they know if you're not a trucking lawyer, if you're getting that case done for, I mean, heck, a lot of these companies, they'll offer you a decent amount of money. I mean, they offer you $1 million. Question is, they're getting a major savings on the true value of that case.
One of the themes of all of the podcasts that we've been doing is you need to try some cases, right?
Yeah.
I see on listservs I, like you, am a member of a couple different Facebook groups for special lawyers and trial lawyers, but you hear all these people say, well, what could I do in my settlement demands to get bigger offers? And my answer is, routinely, well, try more cases, because unless you're going to get on the list of the lawyer that's going to try cases, your offers aren't going to go up.
Correct.
You agree with that?
Oh, no, absolutely. And I think with what I've done on trucking cases and with the cases I've tried, that defense lawyers come at me and insurance companies come at me with a different approach than other lawyers, because of they know I'll take it to the mat. Win or lose, we hope we win them all. We can't. That's impossible. But they know I'll take it to the mat. They know I'll work it up, and that brings fear to them, and that brings risk, and they don't like that type of uncontrollable risk.
Right. Yeah. You are definitely on that list. I know I've been on that list for far too long. I've had defense lawyers say to their carriers, listen, he's nuts. He doesn't care. He'll just try the case because we're treating him without respect. And they're right.
Yeah.
I am nuts, and everybody knows that. But that's for another.
That's why I love you.
It's probably more for my therapist. But so now you've done that. You've started the discovery. Everyone in the case now knows. They know you anyway, no matter how you started the case, because they know Jay. They know who Jay Vaughn is. Now you're getting the documents you want, but now you have to figure out who you want to depose. in trucking cases, like I know in a nursing home case, I've said to people, I'm always going to depose the administrator. I'm always going to depose the director of nursing. At one point, I was always deposing the medical director. I've kind of come off of that, and I put in their place an MDS coordinator. And now with the new laws, I've kind of come off of that. In a trucking case, who are the people you say you just have to depose?
You have to, at some point, not necessarily in this order, you have to depose the truck driver. You just have to. You have to depose the safety director. You have to do a 30B6 deposition of the truck company.
Now, when you say 30B6, you're not talking about the record request that you talked about earlier. You're talking about straight 30B6.
A true corporate designee dep, a true one. And I've had them where the owner of the company was the rep and also the safety director. So it can maybe knock that out in one depot. I've had it where they produced 5 people for one corporate representative depot, and they're like, we got to produce 5 people. And I'm like, okay, that's fine. I mean, just tell me what topics and let's rock and roll. I mean, let's do that.
As some younger lawyers forget, and maybe some experienced lawyers forget, when you notice a 30B6 dep, you're not noticing a person, you're noticing a corporate representative. It's up to the corporation to A, determine who the best person is for each topic, and B, to educate them on that topic.
Absolutely. It's funny.
I've read Kaz's book, so I know these things.
Yeah, absolutely. But at 9 this morning, I had a conference call with the defense lawyer of a trucking case I have in federal court, and the federal civil rule for 30B6 was recently amended to where you now have a mandatory meet and confer on the 30B6 notice before going forward. So you now have to send a draft first. So I sent the draft a couple weeks ago. He emailed me and said, hey, let's do our meet and confer. We had a call this morning. He thought a couple of my topics were broad, which they were. And I explained to him why. I said, there's no way to word these. And I said, I haven't written my questions, but here, let me tell you what I'm going to ask. And I rattled off like 15 questions. He goes, oh. I was like, yeah, it's short, but there's no other way to do this topic. All the other topics, he goes, yeah, those are very specific. And this is it's a backing case. So it's really a one-issue case. So we're looking at doing that depot, the truck company, here in June. But that was a case where I deposed the truck driver first. Truck driver went a place I didn't think he was going to go, which is fine. I let him go there. So now I'm going to do the company to see if they agree with their driver, which the driver's wrong on the rules, or if they're going to separate and say, well, we trained him differently. So the decision you make is, do I want to depose the company first, the safety director first, or the driver? And depend on this, regardless of what decision I make, is this a case where I think I can pitch them against each other?
Right.
So here, I think it's a case that either I can pitch them against each other, which works great for me, or the company sides with the driver, and I already know from all the proper training and the regs, the driver did it wrong. So then either the company's wrong and they just don't know what they're doing, or this driver was wrong at that time. Either way, I'll take whatever path they give me.
So let's talk about those two paths, because we face this stuff all the time, and I don't hear people talking about that too often. So now, if the path is, and again, it's forced upon you rather than you saying what it is. If the company says, well, we trained him differently, clearly he didn't listen, and we can't be responsible for him not following the rules. We tell him the rules, we show him the rules. How do you deal with that if you still want to go after the company and make it a corporate company case?
It's a great question. And I'm at the point where I've stopped getting mad over positions companies take. I've stopped wanting to force them where I want them to go. I'll just let them take me where they want to take me, and I'll figure it out. And I always have plan A, plan B, plan C. And what do you want? You want, ideally, what do you want? You want, if you have a bad crash, you want to depose the driver admit they're at fault, and the driver say the company never trained me on this, and had they did, this wouldn't have happened. Great. And then the company go, yeah, we didn't train him on this. Okay, well, now I got a negligent training case. Maybe the driver wasn't qualified. Maybe
that doesn't happen too often. I'm guessing.
No, it just doesn't. It just doesn't. So so if you just depose the driver and don't depose the company, then you have this big question mark, and you don't know what the hell they're going to do to you at trial. So you got to take the dep, you got to do the discovery, you got to lock them in and learn what is your position as a company on this crash.
Right.
And if they say we did train him on this, and the proper method is something called the Smith system. And before you back up your truck, you're supposed to get out of your damn truck and look behind you and make sure nothing's there, and then sound your horn and back up properly. And this guy didn't do that, and he's wrong. Well, great. That helps you on liability. It's going to help you with the jury. Is it going to make the company look like a big bad motor carrier? No, it's not. And are your direct negligence claims, if you're in a state that allows it, are those probably gone for negligent hiring or negligent training? Yeah, they're probably gone. So at that point, if that's the evidence, and you don't have a punitive case, and you don't have, like mine's a double shoulder surgery case, 2 surgeries, same shoulder, but not catastrophic. My guy's alive. My guy's a truck driver. So in that scenario, so if the direct negligence claims are gone, okay, fine. And so maybe the jury isn't getting mad, and maybe the value's a little less than if it was a big bad truck company. That's just the reality of that case. You can't force the facts. And I think if you try to force it, I think you're 100% losing credibility with the jury. And today's age is, if you have a good client and good injuries and good liability, but now you're trying to put a square peg in a round hole, who's going to get punished? Your client, for your greed and your ego, and you trying to push something that's not there. If it's not there, move on to
I'm so glad you're saying this, because I've been struggling with this I've been practicing law almost 33 years. For at least 25 of those 33 years, I've been struggling, because I've been doing nursing home for 25. That there's so many people who will say to you, hey, do you have your sample interrogatories, or do you have your sample request for production of documents? And they don't take the time to think why. And they just send them. And now you're arguing over profit and loss statements, at least in the areas I practice. You're arguing over budgets when you haven't even proved what happened yet. And I routinely tell people, you've got to take it in tiers, right? You don't get to the corporate stuff, certainly not the financial stuff, until you're proving the corporate liability, I presume.
Right. And so, on this particular case, the driver had been working there for 7 years. It's not a negligent hiring case at that point. He'd been there for 7 years.
Right.
And so is it a negligent training case? I'll find out here in a month when I take the depot. And if it's not, then I'll readily admit the defense lawyer, I don't have a direct liability claim. It's just vicarious liability,
right.
And we're getting the causation, and let's move on. And I think that I feel that I've gained more credibility with the defense bar when I just shoot straight and say, hey, I don't have this here. Well, you didn't plead punitives, right? Because right now, I don't think I have a punitive case. I just don't.
Well, one of the things I've always gotten in trouble with, and I'm curious, well, among many things, but I'm curious how it is in trucking. We used to do specific pleadings, such as, not just negligence and they violated certain federal and state standards, but we would get into understaffing. We would start saying what they were. Then we
itemize.
Yeah. Then I get hit with a ton of motions to either be more specific or dismiss that because it doesn't even state a claim. How do you feel about that in the trucking world?
It's interesting. I have actually a lawyer emailed me yesterday asking for a sample complaint for a conspicuity issue where, there's a visibility issue with the truck. The reflective tape and stuff was covered over with mud or something. And do I have a conspicuity complaint? And I was like, I don't plead that specific. I just say they were negligent. Here's this. I just don't. And I've also taken out, and again, I over the years, I've had your complaints when I was doing a lot of nursing home work. I haven't had one in a while because I stopped doing nursing home cases. But I used to do, these complaints with all these headings, count one, and statement of facts, and it had all the, reallege and incorporate, and I used to do all that stuff. And I just said, you know what? Screw it. I had one judge once in Ohio dismiss the punitive damage count because it was a separate count, not with the others, and said it was something stupid. It was a dumb ruling. So I've changed my complaint format to where I just say comes now plaintiff against defendants and states her cause of action as follows: 1 through 20 or 25, wherefore, sign it, done. I don't have any categories. Each paragraph, if I have 2 or 3 paragraphs on duty and breach, maybe I'll say, based upon the violations in paragraphs 8 through 10, they're negligent or negligent per se, but I don't do categories anymore. I just do one complaint with numbered paragraphs and move on. And I get to the point, here's what it is. I don't itemize anymore. I don't go through and because I remember the old nursing complaints that would have that.
Yeah.
And
and it's interesting because I guess it depends on where your jurisdiction is. So Pennsylvania has fact pleading.
Oh, okay.
New Jersey has notice pleading. But
yeah,
I found the more you put in the complaint, the more problematic it is for you in defending what's in the complaint. And if you don't need to do it, you could say they violated the federal laws and you can deal with what you prove in discovery after that.
Yeah. Yeah. I mean, if they have violated specific Kentucky motor vehicle statutes, I will in one paragraph list each individual statute by number, not by name, just by number. And then the Kentucky administrative regulations have adopted the federal regs, the federal motor carrier safety regulations for trucks. I'll cite that. Otherwise, I just move on.
Interesting. So we've talked about the driver.
Yeah.
We talked about the safety director and the 30B6. Anyone else that's part of, in every case, you're going to depose?
No. I'd say maybe a dispatcher, depending on the issue. It may be whoever is in charge of their maintenance department, if they have a maintenance director. Sometimes, but what if it's a case where, again, which is why the sooner the better, especially if a catastrophic case, fatality, to get it in lit as soon as you can.
Right.
I know sometimes in death cases it's delayed to get the estate opened and someone appointed administrator, but you may learn that they don't do their own maintenance. They outsource it to a third party. Well, if you have a maintenance case and something's wrong with the truck, because a lot of times what you have that's we don't have in passenger cars, if there's what's called out of service criteria, so OOS, and there's out of service criteria for trucks and out of service criteria for drivers. For trucks, you have, a truck and a trailer, a tractor and a trailer together, you may have 10 brakes on the whole truck. If more than 20% of the brakes on the tractor are below standards, whether the air, the brake measure, whatever your mechanic does, if more than 20% are out of service, that truck was illegal to be on the road. If more than 20% of the trailer brakes are out of service, the trailer was illegal. And as a combined unit, if more than 20% of the tractor and trailer brakes are below standards, and I have a book on my shelf that has the guidelines, then that means you could have a case where the tractor and trailer were illegal to be on the road. Now, I had a fatality case in Indiana where we got to the inspection and I'm under the truck with my mechanic and the defense mechanic's under the truck. And they're like, oh God, like we had wires to the wrong place, wires that looked hooked up weren't. And I think all the trailer brakes, the entire trailer had no brakes, all out of service. And of the tractor, only 2 were in compliance. And that was one I didn't have file suit. They paid me a lot of money in that one. I mean,
what you're listening to you, it reminds me of a couple things. It reminds me that there's just a lot of shit to know when you're handling certain types of cases. And I'm from New Jersey, so shit, as you know, is a verb, noun, adjective. It's allowed. But how did you get the type of knowledge that you're just throwing this off the top of your head?
I mean, you and I are cut from the same. We're nerds about this stuff. I mean, we learn, we read. We're always trying to get better. We always go to CLEs and learn. But I like to use experts that like to teach me. I'm not one of these lawyers that works with an expert and be like, I'm the lawyer. Shut up.
Right.
I'm like, oh my gosh, I'm like kid in the candy store. Like, what's this? What's that mean? What's this? On top of that, when I was 20 years old, I was hired by a lawyer in Northern Kentucky as a law clerk. I was in college and I clerked at his firm doing PI for 5 years. 2 years of college, 3 years of law school. But I'm 20 years old, and I'm in town clerking, and he just gives me a file and says, "Here, look at this. What do you think?" I'm like, "I'm 20. I don't know." But he was doing a lot of truck crashes, and he called them form files, but he had 2 big red wells of just stuff on trucks. So every time he'd have a truck case, I was reading the regs. I was learning the stuff, going to depots with him, and he taught me how to practice. He taught me how to practice law.
I think it's great. I mean, I can
yeah.
tell you that I, as you know, am a little bit of a freak over the nursing home regulations, both state and federal. I still read them once a year, re-highlight the annotations to them, just to get a better handle on how nutrition and pressure wounds go together. And I'm sure you're doing the same thing with the trucking regs.
Yeah, I mean, I got a whole shelf of just all my trucking
Right.
books and treatises, and some are industry sources. Some are stuff from the federal regs. I have the book on maintenance. But yeah, if you're going to do it and do it right and get respect, you have to understand it. But there's something else I'd like to bring up.
Sure.
About 2 years ago, maybe a little less. I have a really good buddy. I don't know if you've met him yet. He's a phenomenal truck lawyer out in Texas. His name's Eric Penn. And Eric is, he's the one that got the mega verdict against Werner in Texas in 2017. And Eric's just he's a great dude, and he knows this stuff. He and I were chatting about getting ready for a program we were doing, our seminar, and it was one of those times on the phone where we just kind of broke from the topic at hand, just chatting about the stress of our job, and when you do anything specialized, med mal, nursing home, trucking, products, we're the only profession. If you're an orthopedic surgeon and you have a client that may have something wrong with their eyes or or their nose, you refer them to an ENT, you send them to an ophthalmologist, you heart issue, go see a cardiologist, and they just only have to worry about orthopedic surgery. As lawyers, we're not just lawyers. I mean, we have to be neurologists, neuropsychologists, surgeons, therapists. We have to be biomechanical engineers and accident reconstructionists and mechanics. We have to be economists and accountants and vocational experts and life care planners. I mean, we have to know so much of all these other professions that we don't have any training for. We didn't go to school for. We're trying to learn on the fly from an article, a seminar someone did, talking to your expert for 20 minutes. And we have to be able to talk about it intelligently. I mean, there's nothing more, really more terrifying than sitting down and you're getting ready to pose a defense neurosurgeon or defense biomechanical engineer. And you're sitting there going, I don't know what the hell Delta V is. I don't know what, I don't even know this medical term. Doctor, I don't even know what this means. I went to public school. I don't know what this means. So if you're going to do this and do this right, it's not that you have to talk technical. Like if we talk technical to a jury, we lose, just like you've always said.
Right.
On nursing home cases, if you treat like a medicine case, if you talk about the medicine, you're done.
Right.
But we have to know it, because if you don't know it, then how can you truly understand the behind the scenes stuff? How can you truly get ready to file a motion if you think this expert's not qualified? You got to be able to pose him or her in a way to set them up for Daubert or limit their opinions. So you can't just come in and say, I'm going to depose truck driver here in an hour. I mean,
what I've always said, and I think trucking is exactly the same as med mal, as nursing home, everybody we depose are experts. It's just that simple.
Yeah.
They're experts. If we're deposing 3 nurses next week, guess what? They went to school. They have a license. They have a lexicon that is not ours. If you're deposing a safety director, a truck driver, and someone else, a dispatcher, they have a lexicon all their own. And unfortunately, you need to know it. And that's part of what we do as trial lawyers, right? It's not a matter of just standing up. Everyone says, oh, my daughter will be a great lawyer because she can argue. I'm like, well, okay. I mean, don't get me wrong, I can argue with the best of them, but I kind of don't think I win arguments unless I've prepared for them. I don't think I get, and I think we're gonna stop in a minute and we're gonna talk about the next time I have you on about the trucking case. But I think it's the same with a deposition. Anybody could say who, what, why, where, and when, but you kind of have to do the work to know when to ask those questions.
I mean, preparation is everything. Just like when I'm going to the inspection, I'm preparing. I'm already preparing for trial. I'm preparing for these deps. And when I prepare for these deps, I mean, when I send out a 30B6 notice, do you think I just go to a previous one, pull it up, and in a matter of 15 minutes, file it? I mean, I'll spend a couple days, specifically narrowly tailoring that notice for this particular case and why I need this stuff. Already thinking if I get a motion or have to argue to a judge why I need this stuff. When I prepare for a depot of a truck driver, I'll just spit out the previous outline and say, I'll just go and wing it. I mean, I plan hours in advance. I'll block off my calendar. I literally, when I prep for depots, I block off depot prep for Saul Gruber, and I'll prep all day, and I'll have all my exhibits ready in the order I want them, already with stickers on them. Like I'll map out in my head, where is this going to go? I mean, and listen, but I don't have a volume practice. I have, I don't know, I have 26 cases. That's how many cases I have right now.
But are they all trucking?
Cases. I think about 70% are trucking. Yeah.
It's a lot of cases.
Yeah. About 70% are trucking.
We just had this conversation with a bunch of people, nursing home lawyers. What is the right number? And, one or two said, well, I think you need about 100. Oh. And of course, that was kind of our reaction. And we all agreed somewhere between 20 and 30 is probably all you can handle as one lawyer, maybe even with an associate and a couple paralegals. But Jay Vaughn, look how big you've become. You're like a trucking powerhouse.
Oh, Saul, I appreciate that. I appreciate all the year. I mean, the advice and the calls we've had, the texts we've had, the talks we've had. I mean, listen, I've always considered you a dear friend and one of my mentors, always.
For people who, and most people who are going to listen to this don't know, Jay and I have had more than 15 hours of conversations over the years when one of us is on trial saying, oh God, what do you think this means? And then analyzing what it means. Neither of us are ever right. It really didn't mean anything, but you don't know that. And as a trial lawyer, if you're trying cases, you hit that. Jay, will you do me a favor and join us later on in the year, maybe with a couple other trucking lawyers, and we can analyze the trial of a trucking case?
I think that would be amazing. I think it'd be awesome. It'd be an honor to be on here again.
Yeah. So thank you again, Jay Vaughn, the trucking lawyer, one of the trucking lawyers in the country out of Louisville, Kentucky. You'll notice I say Louisville, right? Jay, if somebody wanted to get a hold of you just because they have questions, and I know you would help anybody who called, what's the best way for somebody to get a hold of you?
Cell phone or email. Cell phone's 859-468-7031. My email is just the letter J and my full last name, Vaughn, VAUGHN, @justicestartshere.com.
Jay, just want to thank you again for joining us.
You're welcome.
And
thank you.
It's been great. Thanks.
Yeah.
Well, again, this is Saul Gruber from Gruber Trial Consulting, your host for The Jury Thinks What. That was a really quick podcast with Jay. Jay Vaughn, certified trucking lawyer out of Louisville, Kentucky, really gave us some incredible tips in handling your trucking case, from getting the black box information, securing the vehicle. He actually has as you heard, an inspection kit with special goggles that have a camera on it. That's some pretty heady stuff. And I want to thank Jay Vaughn again and all the lawyers at his firm who are just phenomenal out of Louisville, Kentucky. And you've been listening to The Jury Thinks What, a podcast by trial lawyers for trial lawyers. And then once again, I am Saul Gruber from Gruber Trial Consulting, and we'll see you soon. Thanks.
That concludes another episode of the Jury Thinks What podcast, part of the Lawyer Minds ecosystem. Thank you for listening, and we truly hope it was worth your time. Please consider subscribing to the show wherever you listen to podcasts. Explore the other content that Lawyer Minds has to offer, and engage with us on social media. Your feedback and ideas are always welcomed. See you next time.